Well, welcome everyone, and thank you for joining me. My name is Lior Samfiru. I'm the employment lawyer, and like every Wednesday, I am here live taking your call, answering your questions, talking about employment law. Yes, this is a live session about employment law, about workplace rights. So you have an opportunity to ask questions. Again, my name is Lior Samfiru. I am one of the founding partners of Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta, and our job is to help educate you, inform you on your legal rights, and of course help you enforce those legal rights. That's why I'm here on this session, to tell you what you need to know. So I have a lot of stuff I can talk about and I'm ready to talk about, but I like it better, and I think you like it better, if I answer your questions. So I'm live right now. I can see a question. If you type it in, I'll see it on my screen, I'll read it, I'll answer it, and you can walk away with the knowledge and the information that you need. Very important, employment law. Other types of law may not impact you every day. Employment law, as long as you have a job, impacts you daily, all the time. That's why it's so important that you know. Maybe you lost your job and you want to know, is that even legal? Can they let me go? I didn't do anything wrong. Maybe it's a situation where you're worried about losing your job. Maybe you're not treated properly in the workplace. You're being bullied or harassed. Maybe your company's not doing anything about it. Maybe your job is changing, your compensation is changing. Can they do that? What to do about it? Well, whatever the issue, the situation, you have an opportunity right now. What a great opportunity to ask me. You have one of the top employment lawyers in this country reading your questions, answering your questions, here for you at your service. So take advantage of that. My name again is Lior Samfiru. Now, before we get started officially here, let me give you some other contact information. If you actually want to connect with me privately, to have a private email exchange or a private discussion, easy to do. Just grab your smartphone, your tablet, desktop, whatever you want. Go to employmentlawyer.ca. Again, employmentlawyer.ca. My phone number is there. My email address is there, as well as that for my entire team. And in addition to that, you can read a lot more there about employment law. You can read about more about your workplace rights. There's forms you can fill out. So that's your resource. That's your hub for anything employment law related. So questions, employmentlawyer.ca, but that's after. Right now, still have time, lots and lots of time to ask your questions and get some answers from me. Now, I always get lots of questions for some reason in the last few minutes of the segment. Don't let that happen to you, okay? If you have a question, ask it now so I have time to read it and answer it. Don't wait till the last minute. I'm going to start answering some questions right now. First question today comes from Nick on YouTube. I am a year away from retirement, but my workplace environment has become very toxic and is causing me a lot of stress and anxiety. I have tried approaching HR, but nothing has been done. What can I do about this? I don't want to jeopardize my retirement. So obviously, if you're in a toxic work environment, that's inappropriate. We all have a right to work in a healthy and a supportive, I should say, work environment. And it's your employer's obligation to keep that, to make sure that's the case. So if you're telling your employer, listen, I'm being mistreated here, this work environment is not healthy, it's impacting my health, they have to investigate it and deal with it. They cannot ignore it. They can't say, well, that's your problem, not ours. It is legally their problem. So in this situation, Nick, if you've done that, you've spoken to your employer, they've done nothing, they haven't made any changes, they left you alone to your own devices, well, this is now potentially a constructive dismissal. You may be able to treat this as a termination of your employment and get severance. Now, that severance could be a lot more than the year. You say you have a year till retirement. That severance could actually be a lot more than a year, depending on how long you've worked there. It could be 2 years of pay. So something you want to consider. The other thing you may want to do, if your goal is not to do any of that, you just want your employer to fix the work environment, is have me send them a letter. I promise you, once they hear from me, it's going to get their butt in gear. Okay, they're going to want to do something about it. So I can either give them a kick in the butt, so to speak, or I can get you out of there with severance. Either way, we can help. But what you don't want to do is just ignore it. It's not going to get better. It's going to impact your health. So do something about that. And to connect with me, Nick, easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. All right, great question. I'm going to continue answering. You see how easy it is. I'm Lior Samfiru, the employment lawyer, here at your service. A few more questions came in. I'm going to answer them right now. Ask yours too, okay? Simon Says has the next question. I love that, on YouTube. A friend was fired for non-compliance with vaccination policy. Now the company has revoked the policy. They have not contacted the ones they fired. What should the fired expect or do? Well, if they've been fired, the company's not going to contact them. Now it's simply about getting them severance. They shouldn't have been fired without severance. So he's owed severance. And I don't know how long your friend has worked there. I don't know if he's been there for a year or 50 years, but he's owed severance. So he needs to contact us. We've been handling hundreds of these types of cases across Canada. We'll resolve it. We'll get him compensation. He's not likely to hear from the company. We need to get involved and get him severance. So anytime you lose your job because of the vaccination status, yes, you're going to be owed severance. If you haven't been paid, and most companies don't pay you, we need to get involved. So have your friend contact me. We'll get to work. And for your friend to contact me, I gave that address. I'll give it again, employmentlawyer.ca. Again, employmentlawyer.ca. All right, excellent. Great question. Next question coming up. Let's see. YouTube comes up with a question from N. Stinson. Can an employer force a fully remote worker to attend regular meetings or mandatory training in the office? Remote work contract only says that can be requested on occasion, nothing about going in regularly. Well, there's exactly the answer. So can they do that occasionally while we have a situation we need you to be in the office next Tuesday? Yeah, they could do that. If they say, well, from now on, we need you to be in every Tuesday, well, that's regularly, that's offside, that they cannot do. So if something happens occasionally, they may need someone to be there for a meeting, for an event, for training, they can do that. But if it's a regular, consistent thing, that's a breach of the terms of employment. The employee doesn't have to accept. They can't be fired for cause for refusing. So the devil's in the details, of course. We want to know, when's the employee requesting, how often, how regularly is this? If the employee is going to go, that employee should write to the employer an email saying, I'm getting a bit concerned here that this is happening more regularly. I'm going to go to this meeting on Tuesday, but I'm not agreeing that this becomes a regular thing. So you want to put that on the record so it doesn't seem like the employee has accepted the fact it can just be called back to work in the office anytime. You may want to have, if whoever this person is, contact me so we can do this correctly. You don't want the person to give up rights they would otherwise have. Great question. Again, you see how easy it is to answer questions. See how easy it is to get an answer from me. All you do is you type it in, I'll see it. And by the way, to reach out to me, you see the address below. You can email help@employmentlawyer.ca. Just go to employmentlawyer.ca and all's there. But right now, I'm live, you're live. Let's answer some more questions. Sunny Marvin on YouTube. I've been at this company for 18 years out of Ontario. They want to give me lieu of notice up to 2 years instead of severance. Can they do that? So yes, Sunny, an employer can give you advance notice of termination instead of paying severance. So if you're owed 2 years severance, okay, if you are owed 2 years severance as an example, instead of giving you 2 years severance, they can give you 2 years notice. Okay, 2 years notice. So, and they would then fulfill that obligation. So yes, they can meet their severance obligations by providing you advance notice of termination. I know it's not something you prefer, because obviously would rather get severance and not have to go to work, of course, but they can do that. Now, here's one thing though I want you to consider. If you're working for a large company, a company that has a payroll of more than $2.5 million a year, so usually it's a company that has let's say 50 or so employees or more. No matter what, at the end of the 2 years, they'll still have to pay you an additional 1 week for every year of service. Okay? So I'll give you an example. Let's say you've been with the company for 20 years. Okay? They give you two years notice. At the end of the 2 years, they're still going to have to pay you another 20 weeks, 1 week per year. Now, that's only if you work for a larger company with more than $2.5 million a year payroll. If you work for a smaller company, they won't have to pay you that extra 20 weeks at the end. Hopefully that makes sense. If not, ask a follow-up question or just connect with me off air at employmentlawyer.ca. Very easy to do that. So happy to chat with you and answer some more questions that way. And guys, you see how easy it is. Still have plenty of time. Ask your questions. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin LLP. Live. You see, I'm live. I'm not bluffing. I'm live. I'm reading questions, answering questions. Ask yours, please, as well. All right. So next question comes from Rosemary, again on YouTube. My sister was put on an unpaid leave because her employer has less work, but they've recently hired a junior member. They haven't recalled her back. What should she do? So here's the thing, Rosemary. Whether or not they have a good reason doesn't matter. An employer does not have the right to put someone on an unpaid leave. They just don't have the right to do that. Whether there's a good business reason or they're lying on the reason, it doesn't matter. So what does this mean for your sister? It means that she has two options. Option number one is she can sit at home and wait. I have no idea how long she'll wait because it's not legal anyway, but she can wait and see what happens. Option number two is she can now consider this leave as a termination of employment and get severance and move on somewhere else. That is the thing that makes sense. Otherwise, she could be waiting, I don't know for how long. What if they don't contact her for the next 2 years? What if they never contact her, right? So it doesn't make sense to wait. There's no right to put someone on an unpaid leave in this situation. Good reason or bad reason, there's no right. So Rosemary, have your sister contact me, okay? She could do that through employmentlawyer.ca. Again, it's employmentlawyer.ca, and we'll get her severance. It's going to be very easy. We can get that probably in 2-3 weeks. It's not hard. So have her contact me through employmentlawyer.ca. That, I think, is the thing that makes the most sense for her. All right. N. Stinson has a follow-up question. Can an employer force a fully remote worker to install and use a camera for meetings and training? Yes, they can do that. It's not an unreasonable request for remote workers to use technology to make the work better and more efficient. So yes, as long as it's something that's used only for work purposes, it's not, you're not putting a camera in your office, your home office that is on 24/7. But if it's a web camera that you turn on for meetings or for work purposes, yeah, that's okay. They could do that. All right, great questions, guys. Today, some of the best questions. So please keep them coming. Keep asking questions. I'll keep answering them. Very easy to do. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, here live for you. All right, Martina on YouTube has the next question. My company called me into a meeting and accused me of theft. They terminated me on the spot, but the accusations are false. I'm worried about my record of employment and being able to get a new job because of this. What can I do? Well, you're right to be worried, because what are you going to tell a prospective employer? We need to get involved ASAP on this. If you didn't steal, if the allegations are false, this is clearly then a wrongful dismissal. So number one is we can get you a new record of employment. We can even get you a letter of reference because you didn't deserve to be let go. We probably can't get them to take you back, but we can get you a letter of reference, a new record of employment, and we can get you severance as well. And again, I don't know how long you've been there, but that could be, if you've been there for a long time, it could be as much as 2 years' pay. Even if you haven't been there a long time, it's still going to be substantial. So please, let's have a chat. If they're accusing you of doing something and you didn't do it, theft obviously is a big deal. If you stole, that's going to be cause. But if it's false, then it's a wrongful dismissal. And remember, the company has to prove that you stole. You don't have to prove that you didn't steal. They have to prove it. So if you didn't do it, they can't prove it because it never happened, right? So that's why you need to contact me. You don't want this to be something that's going to hurt you for the next however many years with future employers. Let's get this resolved, get a new record of employment, reference letter, and severance, okay? So this is Martina. Please please reach out to me and let's get going. And you can do that through employmentlawyer.ca. So let's see, Rosemary. So yeah, you were saying about your sister that's put on an unpaid leave. She's been there for 15 years. She's worried about losing her seniority, but she's already lost it, right? She's off work. The problem here is this: if let's say they contact her in a month, as an example, and she goes back, right? The problem by doing that is now she's given them the right to do it again. They didn't have a right to put her on a leave, but she accepted it. She let it happen. Well, now because she's done that, they could do it again. And what happens then if every few months they put her on a leave for a few months? She won't be able to do anything about it because she let it happen that first time. So it makes no sense to stay in this situation. Now, after 15 years, again, I don't know your sister's job specifically, and I don't know her age, but she could be owed anywhere from 12 to maybe 18 months pay, even more, depending on on her age and position. So that's a significant amount of compensation that she's owed. It makes no sense when the employer just puts you off on a leave indefinitely to just say, okay, I'll just sit at home. That makes no sense. So have her call me and let's get going on this. Happy to connect with her. Again, employmentlawyer.ca. This is a good time here to remind you about severance and how do you know how much severance you're owed, or maybe your friend, your brother, your sister, how much they're owed. Easy to do. You can call me and I'll tell you, of course, but there's an even easier way to do that. We have created our severance calculator. Very easy, very accurate. So all you do to get the severance calculator, you grab your smartphone and you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that address on the screen below me. And when you go there, you'll see our severance calculator tool. Easy, right? It's free. It's anonymous. It's easy to use. There's no phone numbers you have to put in there. There's no email address you have to put in. You don't have to put in your name or the company's name. It's just there for you. You input how many years you've worked, the type of job, and your age. And you press the button and it's going to tell you how many months of severance you are owed. Check it out even if you haven't lost your job. Even if you're just curious, you're going to be surprised by the number. Most people are. So many people assume I get a week's severance for every year of service, maybe 2 weeks. Wrong. Don't believe me? Check it out for yourself, pocketemploymentlawyer.ca. Tell others about it. Okay, maybe you're speaking with your neighbor across the street. They're worried about losing their job. First thing you tell them is just for your information, go to pocketemploymentlawyer.ca, use the severance calculator. You'll be glad you did and make it the first place you go to when you want to know how much severance you're owed, the real amount. All right. You got some more time, guys. 13 minutes or so. So ask questions. The next question comes to us from John. I was hired for a 20-month contract and let go after 8 weeks because I was doing work outside of my scope, according to my employer. This was not accurate. Am I owed any severance because my contract was terminated early? Excellent question. So what happens on a fixed term contract? So fixed term meaning you're there for a fixed amount of time. In this case, I guess it's 20 months. What happens on a fixed term contract is if the company lets you go before the end of the contract, they have to pay you the balance of the contract. So if you were let go 2 months into a 20-month contract, well, they still owe you another 18 months. 18 months. So if they let you go before the end of the contract, they have to pay you the balance, the difference. So yes, they owe you that. So John, you got to connect with us ASAP here, okay? So we can get that amount. And it's a good reminder for everyone there with the fixed term contract. Maybe you signed a contract for a year. If you're let go before, in most cases, they have to pay you the balance. Even if you're not working, they still have to pay you, all right? Employmentlawyer.ca, you see that address below me, is the place to go to connect with me, my team, phone numbers there, email address, it's all there. Just go to employmentlawyer.ca. All right, more questions coming in. Next question I'll answer from Suzette on YouTube. Can you request your employer to update your contract to reflect new duties? Would it be possible for them to claim you have a lesser position if they fire you without that? No. So first, you don't need to update your contract. It doesn't help you. And in fact, it could be a very bad thing. By us asking your employment agreement to be updated, the company can use that opportunity to add other terms in there that you're not going to be happy about. So you don't want that. You do not want that. Now, if you don't update it, it's not going to allow the company to pay you less severance, simply because your job is what you do, not what your contract says. Most people, have a contract from 10 years ago when they had a different position. What matters is the actual job, the functions that they perform now. So I wouldn't worry about that. I wouldn't ask. And by the way, even if you ask, there's no obligation for them to say yes. So this is simply something you don't need to worry about. In fact, if your job changes significantly, you're actually better off not having any new contract. It may make the old contract invalid, which is what you want. So stay away from doing that. There's no need for that, Suzanne. All right. Simon has another question on YouTube. How does one refuse to be put on an unpaid leave? If that happens, what should someone do to refuse the unpaid leave? Well, no. By refuse means you're not sitting at home and waiting. By refuse, what I mean is you're treating it as a termination. We take the position, employer, by putting me on a leave, you've terminated my employer, now pay up my severance. That is what a refusal is, okay? You can't, but I don't mean that you show up to work anyway. That doesn't work. You can't do that, of course. But by acceptance means you're sitting at home. Okay, you told me to sit at home and be a good boy and wait. Okay, I'm doing that. That's acceptance. Refusal is, no, I'm not doing that. I'm finding another job, but I'm making you pay me my severance. I'm treating that as a termination of employment. Okay, to do that, you need our help. Easy to do. Go to employmentlawyer.ca. And I think, yeah, okay, good. So hopefully that makes sense, Simon. If not, let me know. Amanda on Facebook has a question. Can my employer lay me off and immediately hire my position after citing work shortage for their reason? Yes, they can do that. That makes them liars, perhaps, and that makes them dishonest and not necessarily maybe good employers, but it's not illegal. Your employer can let you go for no reason, bad reason, false reason, as long as they pay you severance. So if they tell you it's a work shortage and they're lying because the next day they hire someone to replace you, again, they're liars, right? But legally, that is okay as long as they pay proper severance. Now, what I would bet almost anything that whatever severance was offered in this situation, Amanda, is a lot less than what you're actually owed. Because in 90% plus, 90+% of cases, that's exactly what happens. Whatever you're offered is a lot less than the real amount, what you're actually owed. So that's a wrongful dismissal. Wrongful dismissal, simply a situation where you're owed more severance than what you've been offered. All right. So Amanda, you still need to give us a call, but it's not really about the reason you were let go and the dishonesty of that reason. It's about your severance. Okay. And you too, Amanda, can go to pocketemploymentlawyer.ca. You can do that right now. Use our severance calculator. See that address below me and find out how much you're owed. I bet you anything. You know, I have these magical powers. I can see the future. I can bet you anything that whatever you've been offered is less than what you're owed. So thanks for that, Amanda. Sonny Marvin has another question. Is there any limit on the weeks my employer pays at the end of my lieu of notice instead of severance? For example, 22 years is 22 weeks. So yeah, that amount would be a maximum of 26. So what I told Sonny is that regardless of how much notice you've received, advance notice of termination, if you work for a larger company with more than $2.5 million a year payroll, your employer still has to pay another week's pay per year of service at the end of the notice. That caps out at 26 weeks. Okay, so hopefully that makes sense. But you only get that if you end up staying till the end. So if they give you 2 years notice and you leave before then, maybe you found another job, etc., then you won't get that extra payment at the end. All right. So hopefully that makes sense, Sonny. If not, I'm still here. Ask question. So I think I'm caught up, but we still have some time. Please ask your questions. I'm not leaving here till I've answered all the questions that come in. You still have some time. Ask those questions. Everyone that's asked questions has got an answer. It's easy to do. You have that opportunity as well. Maybe you have a follow-up question to something you've already asked. Very, very easy to do. Again, I'm Lior Samfiru, the employment lawyer. A couple of things I wanted to talk about in between your questions. And this is something we've already alluded to. And that is that if your employer does something that they're not allowed to do, and I'll give you some examples in a second, but if they do something that they're not allowed to, but you accept it, you don't do anything, you don't say anything, you just continue working. Maybe you're not happy, but you don't want to rock the boat. The problem with that is you've given them the right to do it again. You've opened the door or allowed your employer to open that door. And that's a huge, huge, huge problem. I'll give you an example. So an employer does not have a right to change your hours of work. Certainly anything significant, they can't. So they do it. I'm going to be the good soldier. I'm not going to say anything. It's not comfortable, so I'm just going to continue working. Well, okay, that's very nice of you. But by allowing that to happen, you now are giving them the right to do it again. And then the next time they change it, and the time after that, and time after that, you won't be able to do anything because you let it happen that very first time. So, and before you know it, the job or the hours you used to have are no longer the hours that you have. So you have to be very careful. Same thing applies with changes to your compensation, changes to your commission structure, changes to your responsibilities. So anytime you're facing something where your employer is doing something like this, they change the terms of employment, you want to think potentially constructive dismissal. You may want to be able to say, you know what, no, this has gone too far. I'm not comfortable with this. I don't want to open the door for you to be able to do things to me again and again. I'm going to treat this as a termination and get severance. Okay. If you're ever in that situation, before you do anything, call me or email me. Okay. To do that, employmentlawyer.ca. Again, employmentlawyer.ca. All right. Let's see. We have another question here from Linda on Facebook. Can my employer force me to take vacation at a specific time each year? Yes, it's a good question, and the answer is yes. An employer is allowed to schedule your vacation for you. Now, most employers don't do that because it's going to create upset employees. Most employers say, you tell us when you want to take vacation and we'll approve it. But an employer can say to you, Linda, I've decided that this year you're taking vacation on December 1st. And Bob, you're taking vacation February the 15th. They could do that. Now, again, not something that most employers do, but legally they are able to do that. Okay, that's not illegal. And if that's what your employer does, I would talk to them about it, maybe try to make them understand that that's not the best way to do things. But again, legally, that's okay. All right, Archie has our next question. What if those changes are small and over a longer period, but result in a large change overall? Can you decide after many changes that it's too much? Yeah, that's a tough question to answer, Archie. And I know exactly what you're saying. That's a very good comment and good question. So it's like death by 1,000 paper cuts. Each paper cut on its own may not be a big deal, but once you have 1,000 of them, yeah, it's a huge deal. So I can't tell you more other than to say that in every situation, we have to look at the facts of that specific situation. If it's clear what the employer is doing, we may be able to say, employer, I'm not going to accept any more changes. I'm afraid that we're going down a path that's inappropriate. And if they do, despite what we say, they do that anyway, that may be a constructive dismissal. So that's why I always say, you never take the view that it's been a constructive dismissal before speaking to me. You don't decide on your own. You don't leave on your own. You have to talk to me because we need to do this correctly. And not every single change is a constructive dismissal. But you're absolutely right, Archie. This whole death by 1,000 paper cuts, it's much more difficult than if you're dealing with one big major change. So Archie says, what if they reprimand you for refusing changes? Let them reprimand you. So what? It doesn't change your legal status, doesn't change your rights. They can't suspend you. They can't let you go for cause because of that. If they sleep better at night by reprimanding you, all right, it doesn't matter. Okay. Tusk employee, don't refuse changes. It doesn't matter. I wouldn't worry about it. It's much more important that you put in writing that you're not okay with this, that this is not fine, and that you're going down a path that you're not going to agree to. That is how you preserve your right. Reprimand, warning, it doesn't mean anything. Guys, I think I'm caught up on questions today. Let me give you some other information. So tomorrow, Thursday, one of my partners, Alex Lucifer, will be doing his own live stream session at 12 o'clock tomorrow Eastern time, talking about employment and disability law issues. So Alex, in addition to practicing employment law, also deals with disability issues. So if you have an issue, let's say with an insurance company, you're off on disability, they're threatening to cut you off, or maybe you're trying to get back to work from a disability. What does that mean? How can that happen? That's a good time to come in and ask questions. So Alex will be here tomorrow answering those questions at noon Eastern time. For me, that is it for today. I will be back next week. Same time, same place. Hope to see you. But in the meantime, if you have questions, if you need my help, if you want me to roll up my sleeves and get to work to help you, don't wait till I'm back here. Don't wait a week. It makes no sense to do that. Contact me. All right. Let's connect. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca. We can have a chat today if you want. I'm not going anywhere. I'm just shutting down the camera, but I'm getting back to work. So employmentlawyer.ca, the place to go to. Thank you guys for all the questions today. Always great questions. Always a privilege to be able to answer them. Thank you very much again, and we'll see you soon.